Justice Thomas has written a very interesting opinion about whether or not the law can stop social media like Twitter and YouTube and Facebook from censoring material. Is the solution worse than the problem? You'll hear why it is a difficult choice on the Dershow. Justice Clarence Thomas has just written a concurring opinion which raises really fascinating issues about how we can control the excessive censorship of the internet without in any way seriously intruding on the First Amendment. It was a concurring opinion in a case which, ironically, the then President Donald Trump was trying to engage in censorship on the internet. That is, he was precluding certain people who obviously were very critical of him of responding to his Twitter feed and forwarding his Twitter feed. So ironically, then President Trump, who was railing against the censorship of the media, was himself trying to control his own Twitter feed. And of course, then Twitter banned him completely. And the case went to the courts, and it came up to the United States Supreme Court about a week ago. And the court dismissed it as moot, correctly, because he's no longer the president. And the issue was whether the president, as president, an official of the government, can control access to his Twitter account, which he used both in a private and a public capacity. It would have been an interesting case, but it was moot because he was no longer the president by the time the case came up to the Supreme Court. So unanimously, the Supreme Court dismissed the case as moot. But that didn't stop Justice Thomas from writing an interesting opinion, really more like a law review article. It's all dictum and concurring. It's not the law. But he basically said, look, we have a problem, and we're going to have to deal with this problem sooner or later. And inevitably, there's going to come a case that the United States Supreme Court will have to take about whether or not the major media, internet outlets, Facebook, Twitter, Google, are going to be able to control what we see and what we hear. He was focusing on Twitter in this case because that was the case before the court. And Twitter has a policy of saying they can tell anybody that they can no longer be on Twitter for any reason or no reason at all. It's right in their policy. They can do it for no reason at all. If they don't like the tie you're wearing, if they don't like the party you belong to, presumably if they don't like your race, they can say, no blacks allowed, no whites allowed, no Jews allowed, no gays allowed. Maybe that would violate other public accommodation laws, but according to at least the Google standards, they can do anything they darn please because they're Twitter in this case. But Google has standards as well, and so does Facebook. Facebook now has a, quote, Supreme Court of distinguished people deciding whether to censor or not to censor, but it's still private censorship of public discussions. And so Justice Thomas, who was never my favorite justice, but who every so often comes up with really interesting and quirky ideas, akin to those sometimes articulated by, I think, his mentor, it's fair to say, Justice Antonin Scalia. And, Scalia was a good friend of mine. I enjoyed my conversations, my interchanges with him. We rarely agreed, but we agreed to disagree, and we agreed to argue and debate. And it was always fun to debate with a brilliant mind like Justice Scalia's. And so today, I want to use the Dershow as an opportunity to begin a debate and a discussion with my audience, my viewers, my listeners, as to whether we should leave the internet alone or whether there are ways of dealing with the power, the enormous power of the internet. Justice Thomas suggests three essential approaches, all of which raise problems, but all of which deserve serious consideration. The first issue he raises is whether or not today Twitter and Facebook and Google and others are can you say they're common carriers? Common carriers are trains and buses. They're open to everybody. And you can't say to somebody, we don't like the way you look, you can't get on our train, you can't get on our bus. And there's a whole law of common carriers that goes back to before the Constitution, before the First Amendment. And so he says, look, the First Amendment was written with common carriers in mind. Everybody at the convention, everybody who voted for the First Amendment was aware of exceptions for common carriers under British law and under early American law. But, common carriers generally don't involve First Amendment rights. They involve, as I say, mostly transportation. I'm sure they applied as well to the Pony Express and to other ways of transporting at an age when really we were talking about horses and buggies and steam engines. Now, there is one analogy he makes that comes a little closer. When the telegraph was first invented, it was seen as a common carrier because it was akin in some ways to railroads. It used wires that crossed the country, and it was something like a common carrier. And there are cases that say that the telegraph company can't discriminate and presumably can't decide that they don't like your message. I wonder if that really is the law. If somebody was using the telegraph to solicit child pornography or other crimes, I would imagine that the telegraph company would censor some of those communications. But I'm not sure, and I'm not sure there was much law on it. I'm just not familiar with the extent to which the telegraph company could be regulated in its First Amendment content. The same thing is true of telephones. Of course, telephones are different because if I call you on my telephone, nobody's listening in. And so nobody knows whether or not a crime's being committed or we're discussing something that would be illegal or improper. So the telephone company hasn't tried to interfere with your right to communicate with me and my right to communicate with you. Telegraphs are different because they're readable and they're open. And so these are very, very interesting approaches. There are dangers to regarding the internet communicators as common carriers. It could restrict First Amendment rights. It would mean that they have to treat everybody equally and every idea equally. What about medical misinformation that could cause deaths? What about communications that are criminal in nature, that incite violence, or that communicate extortion or other kinds of things? So it's not a complete answer, but it's certainly worth discussing, common carrier. The other one that he mentioned was a kind of a public accommodation or open accommodation laws. If you hold yourself out as open to everybody, if you say, look, anybody's welcome in my hotel, anybody's welcome in my train, you can't suddenly say, no, except for you. Well, you're not welcome because of your race. You're not welcome because of your religion. And so the question is, can Google and Twitter and Facebook say, you're not welcome because of the content of your ideas? We don't like the content of your ideas. That's a real question. And the third question that he implicitly poses, he relates it really to the first two, but it can be also seen as independent. Can the antitrust laws come in and regulate these three giants that today control so much of our communications across the country? Again, if three newspapers controlled all of the media in the country, if the New York Times, the Wall Street Journal, and the Washington Post had a market share of 95%, it doesn't. It's not even close. The New York Times has a readership of, maybe 1 million. The Wall Street Journal, 1.5 million. Who knows? But that's a tiny fraction of all the media. But the social media do have dominant control over information flow. And so could the antitrust laws be used to control content? These are very hard questions. Or put it more negatively, can the antitrust laws, public accommodation laws, open access laws, common carrier laws be used to control censorship by the media? Can it be used to send a legal message to the media? No, you have to have standards. You can't do what Twitter does. You can't say, we can cancel you for any reason or no reason at all at any time without explanation. No, you're obliged to at least have a standard, to at least try to articulate what your criteria are. So this debate will continue, and it will continue unabated. And I think we owe a word of thanks to Justice Thomas for putting this issue in the forefront of the American consciousness. When a justice of the Supreme Court writes an opinion, people listen and people pay attention to it. Look, what's going on with the public, with the internet today is disgraceful and unacceptable. They are imposing massive censorship. I think I've mentioned to you most recently my debate with Robert Kennedy over vaccination. I take a more pro-vaccine point of view. He takes a more skeptical point of view, but neither of us take positions that are irresponsible or convey misinformation or wrong medical advice. And yet it was taken down by YouTube. You cannot today go on YouTube and watch my debate with Bobby Kennedy unless they put it back up. I haven't checked recently. YouTube also took down a very interesting discussion sponsored by the Steamboat Institute, which is a middle-of-the-road, conservative debate platform. I recently debated Robert Post, the former dean of the Yale Law School, on issues regarding academic freedom and free speech. It was a really good debate. It was as good as any class discussion, and it hasn't been taken down. But YouTube suspended Steamboat for a week for basically challenging its decision to take down a discussion of the elections. And it's getting worse and worse and worse. And the internet providers are becoming more and more powerful. They're flexing their muscles more. They're censoring more. And they, with the exception possibly of Facebook, which is at least addressing the issue by its, quote, Supreme Court, which makes me nervous. I don't like private citizens, platonic guardians telling me what I'm able to read and what I can't read, but it's probably better than nothing. But as far as I know, Twitter's doing nothing. It's just making its own decisions and deciding what you can tweet and what you can't tweet and what you can respond to and what you can't respond to. That seems to be an unacceptable situation in a country devoted to the marketplace of ideas. But the problem is the cure worse than the disease? Do we want to give the government power and authority over private social media, which themselves have their First Amendment rights? They are, in some respects, like the New York Times and the Supreme Court has said in the Miami Herald case. You can't tell the New York Times or the Miami Herald what to print and what not to print. Can you tell YouTube what to put on and what not to put on? Very, very difficult, very complex questions, and questions that deserve very serious consideration. Today in the Wall Street Journal, there's a very good article. I could have written it. It's what I've been saying now for a long time about why liberals on college campuses aren't defending free speech. Why the new liberal mantra on college campuses is that free speech is patriarchal and colonial and intersectionally violative, and you name it, every cliche in the book to try to diminish the role of the marketplace of ideas and free speech, that free speech is part of white domination, and absurd arguments, but arguments that are finding currency on university campuses. So we're seeing a little bit of pushback, but we're seeing it in the pages of the Wall Street Journal, not so much in the pages of the New York Times. We're certainly not seeing it on CNN. We're certainly not seeing it on MSNBC. Today, free speech has become an issue more of concern to the center-right than the center-left. We liberal Democrats who really maintain our position as civil libertarians are a shrinking minority on academic campuses. We are endangered species, and it's a very serious problem. You might want to watch my debate with Robert Post. We talk a lot about what's going on college campuses. It was sponsored by Steamboat, so if you just Google Steamboat Dershowitz Post, I'm sure you'll find it, and I think you'll enjoy it. It was entertaining and thoughtful. Post is a brilliant, brilliant academic, former dean of Yale Law School. I started the debate by saying we have major diversity in this debate. We have two old, white, Jewish men born in Brooklyn, clerked for the same judge, Judge David Bazelon, teaching in elite law schools and academic institutions for many, many years. But despite our similarity of background, we had considerably different views on some matters of academic freedom and how to approach issues of free speech on college campuses. So you might find it useful and interesting. But I regard today's show as the beginning of a debate. You can go and read Justice Thomas's opinion. It's available online very easily. It's only about, 12 or 13 pages long, and it's well written. It's like an op-ed. It's very easy to read, and he lays out the arguments that I've just suggested. And please read it and call me and let me know what you think of it. Let me know whether you think there's a solution to this problem. I've kind of thrown my hands up and said it's a problem. We know it's a problem. It raises serious questions about open society and freedom of speech, but the solutions may be more dangerous than the problem itself. So maybe you can persuade me that there are solutions that are less dangerous than the problem. So please call in. Please have your wits ready and make your calls and comments to the Dershow about freedom of speech in the internet and Justice Thomas's interesting opinion. Now, my favorite part of the Dershow, the wits, our first call.
Hi, Professor Dershowitz. My name is Oliver. I'm calling from Slovenia, Europe, and I'm a big fan of yours. I have a question about the US voting system if compared to the EU voting systems. In all the EU countries, all types of voting, in person, absentee, early voting, require an ID, a signature, and a registration in official voting registers. Absentee voting is very limited, only to hospitalized voters, to inmates, this is allowed, and to similar situations. Early voting is limited to just a few days before the voting dates, with mandatory prior request. Ballot harvesting is inconceivable, and therefore it's not even regulated. Why do you think that in the US the discussion is based on such basic voting principles that are completely undisputed here in Europe?
It's a great question. I think the answer is one word: race. We know that race was used for many years in our country under Jim Crow laws to eliminate voting by African Americans. I'm not in any way suggesting that the laws that have been passed in Georgia and now a number of other places, pending laws, are anywhere like Jim Crow. It's absurd. If during the Jim Crow period we had voting regulations like in Georgia, everybody would be applauding them. But people have greater expectations, and people worry that the motive behind these laws are to make it more difficult for minorities to vote and to make it easier for Republicans, which don't generally get a majority of minority voters, to win elections. So race, I think, helps to explain why we're a little bit more sensitive to voting restrictions in this country than perhaps around the world. But what a great question. What a great insight. And you've certainly taught me something I was not aware of, how easy it is to vote in EU countries. Thanks.
This is Peter from Berlin. Thank you for your great show. Here's an art question hypothetical. Assume that you purchase art that later you learn was stolen. When should a purchaser of art prevail by arguing that the art object should not be returned to a previous owner because the purchaser was a buyer in good faith? And for art stolen during the Holocaust, are there exceptions to the buyer in good faith defense? P.S. I have paid my tuition several times.
Well, thank you both for paying your tuition. For a great question. I've been deeply involved in efforts to restore stolen Holocaust art. It's very complicated because there are art that was just plain ordinary stolen. People were taken out of their houses. They were sent to the gas chambers, and the Nazis took their art. Those are somewhat easy cases. There are many other cases during the early 30s, particularly when the Nazis came to power, and they forced Jewish art dealers and art owners to sell to the Nazis at prices ridiculously below the market value. And some of those are regarded as stolen. Some of those have been regarded not as stolen. The general law is, if you're a bona fide purchaser, if you bought the art without any inclination or indication that it was stolen, generally they can't take it from you. They may have the right to buy it back from you, but they can't take it from you without payment. But, you know, Holocaust art is different because anybody who bought art without a provenance between 1933 and 1945 should be on notice. About 10 years ago, I bought a Dutch painting at auction, and they said they were going to send it to me. And I said, no, don't send it to me until you send me the provenance. It's a Dutch painting, and it was painted in the 1920s, and I need to know that it didn't come from a Jewish home. And it took me a year, and it took them a year to trace back the provenance and discover that, no, sure enough, it was bought, and it was bought after the war, and it had a perfectly proper provenance, and I bought the art. But I wouldn't have bought it because I'm on notice. Any art that has any connection to Germany or any of the countries occupied by Germany after 1939, you have to have exquisite provenance, perfect provenance, and even then you have to what raised doubts about whether or not the provenance could have been faked. So it's a very difficult question. And there are many, many cases in the Supreme Court. I've helped litigate some of those cases. Some of the art we've gotten back for families, some of the art we've not gotten back for families. It's very much a work in process, and I'm very, very sensitive to it. I would never buy a piece of art that had any question associated with it. And if I ever did, I'm sure I would just return it to a family of people that were descendants. But there are complications, and it's not an easy area of law. There are some lawyers who specialize in this. My friend Stuart Eisenstadt, my former student, has done wonderful things in terms of getting payments to victims, slaves, and others, people who were killed during the Holocaust. He's devoted so much of his life to getting reparations. He deserves tremendous praise for the efforts he's made on behalf of survivors and their families. So art is a complicated issue. Let's go to our last caller for today.
Hello, Professor. On yesterday's show, you spoke about how you would support the boycott of the 1936 Olympics in Berlin. There's a lot of talk about boycotting the 2022 Olympics in Beijing, considering the genocide of the Uyghurs, which we don't know all the details, but it looks like it might be comparable to the Holocaust. And I'm not trying to put down the Holocaust in any way, shape, or form. Would you support a boycott of the 2022 Winter Olympics in Beijing? Thank you very much.
Thank you so much for your great question. As I've said before, these are matters of degree. Berlin was the worst because Hitler wanted to use Berlin as a showcase for racial superiority. He wanted to prove that white Germans, Aryans were superior in every way, including athletically, and he imposed restrictions. Jews couldn't run. The number of African Americans and other people who were not allegedly Aryans were restricted. The Olympics itself was tainted by racism. Beijing is different. The country is a terrible exemplar of human rights violations, particularly the way it treats Muslim citizens and dissenters. On the other hand, the Olympics will be conducted fairly and openly, and it won't be designed to prove Chinese superiority or the superiority of the communist regime. So it's a closer question. I think a lot about the young men and women who spend their lives training for the Olympics. So I have a strong, strong presumption against bowing out of the Olympics. I think it was right to do in 36. I think it was wrong to do when Jimmy Carter did it. And I think probably it would be wrong to do it for the Beijing Olympics. But I have an open mind. I'd be interested in hearing some of your views on this. You know, today, again, I've learned so much from your questions. It's just brilliant questions, great insights, great thoughts. So please keep telling your friends to subscribe, to listen, to view, and most importantly, to send in good questions and call in good comments. That's the heart and soul of the Dershow. So thank you for listening, thank you for watching, and thank you for sending me great questions on the Dershow. An important part of the Dershow is your voice, your questions, your comments. Please call 24/7. The number is 216-710-0050. Keep your comments short and to the point. Again, the number for you to call 24/7 is 216-710-0050. Hard questions, criticisms, everything's fine. Just keep your questions short, and I'll answer them all on the Dershow.